So thank you very much for joining us today. This session looks at antisocial behaviour and the Court of Protection. It's something that I've found is creeping into cases that we're dealing with a little bit more, and perhaps that there isn't the knowledge out there in terms of the Court of Protection and what it does, as there are the other courts in the land, certainly the county courts, magistrates courts, crown courts. So we thought it would be useful to look at the role that the Court of Protection can play when dealing with antisocial behaviour and how that can help. So my name is Kirsty Varley and I'm a partner and higher courts advocate in the housing litigation team. And as I said, we're going to look today at the Court of Protection when it becomes involved in cases and how it can actually be a help. There will be the opportunity for questions at the end, so please feel free to take that. If you think of a question, as I say, please put it in the Q&A function and I will get to them at the end. There's plenty of time for questions. So if we're going to talk about the Court of Protection, I'm sure most of you will be aware that becomes involved when a person lacks capacity to make decisions. So I thought it would be useful for us to have a bit of a recap on capacity. For those of you that attended the session that I did a couple of months ago, you'll recall it was a full session on that, but this is just a very quick recap, just so that people understand what capacity is, what we mean when we say somebody lacks capacity. So having mental capacity means that the person, or P, is able to make their own decisions about things that affect their own lives. And there are a number of principles around capacity that are set out in the Mental Capacity Act 2005. And there are 5 main principles that really govern the way that people and people's capacity is assessed and decisions are made on their behalf. So the first principle is that there is a presumption of capacity. And this means that every adult has the right to make his or her own decisions, and that people must be assumed to have capacity to have the right to make their own decisions and have capacity unless it's proved otherwise. So this means that you can't assume that somebody can't make a decision for themselves just because they have a particular medical condition or disability. And in fact, if you were to do that, you were most probably going to be discriminating against them in any event. So that is something that you want to avoid. Principle 2 is around individuals being supported to make their own decisions. And principle 2 says that a person must be given all practicable help before anybody treats them as not being able to make their own decisions. So this means that you should really make every effort possible to encourage and support people to make decisions for themselves where you can do. And if a lack of capacity is established, it's still really important that you involve the person as far as possible in making those decisions. So it's really about giving the person as much autonomy as you can over their own lives and decisions about their own lives. Principle 3 is around unwise decisions. And this means that people have the right to make decisions that others or even you might think are unwise, eccentric, etc. You can't treat somebody as lacking capacity just because you don't agree with the decisions that they're making. Everybody has the right to their own values, their own beliefs, and their own preferences, which may not be the same as those of other people, or in fact many people. People have the right to that and to make an unwise decision. Principle 4 is around best interests. So anything that's done for or on behalf of a person who lacks mental capacity has to be done in their best interests, and there are some particular principles that have to be followed when decisions in best interests are being made, and I will come on to those in later slides. And then finally, principle 5, which is the less restrictive option. So this says that somebody who's making a decision or acting on behalf of a person who lacks capacity must consider whether it's possible to decide or act in a way that interferes less with the person's rights and freedoms, or whether there's any need to decide or act at all. And any intervention that's made should be weighed up in the particular circumstances of the case. So now we've looked at capacity, we'll move on now to what is the Court of Protection. Well, the Court of Protection makes financial decisions or welfare matters for people who can't make those decisions for themselves at the time that they need to be made. So they lack the mental capacity that we've just talked about in the first couple of slides. The Court of Protection is based in London. Most cases are heard by district judges and a senior judge, but they can sometimes be heard by High Court judges. Cases can sometimes be transferred to a local court for a hearing. And I am aware, for example, at Manchester County Court, there are a number of judges that do Court of Protection cases. So there is that ability to have them heard locally if need be. And when does the Court of Protection get involved? Well, the Court of Protection will get involved when it needs to decide whether a person has the mental capacity to make a particular decision for themselves. It can also appoint somebody called a deputy to make ongoing decisions for people who lack mental capacity. So this is a person who will effectively deputise and make that decision on their behalf. Or if the issue in relation to capacity is a one-off, so it may be that capacity may return and that there's a specific reason why this decision needs to be made at a particular time, or as capacity is decision specific. In that instance, a person can be given permission to make a one-off decision on behalf of somebody else who lacks the mental capacity to make that decision. The Court of Protection will also get involved when it needs to handle urgent or emergency applications where a decision must be made on behalf of somebody without delay. For example, if there's issues in relation to medical treatment, for example, that may need to be made, and it needs to be made in the person's best interest, and the person doesn't have capacity, there's nobody else who can make the decision, that could be an incident where the Court of Protection becomes involved. The Court of Protection can also make decisions about lasting powers of attorney or enduring powers of attorney and consider any objections to their registration. Now, the terms lasting power of attorney and enduring power of attorney are ones that you may have heard. I will come on to what they are in later slides and explain what they are and how they interchange with one another. The Court of Protection can also get involved when it's considering applications to make statutory wills or gifts, and those would be wills or gifts being made by a person who perhaps doesn't have the requisite legal capacity to do so. And finally, and again, one of the most important roles that the Court of Protection have, it will make decisions about when somebody can be deprived of their liberty. And we do sometimes see this in housing cases where if somebody's had a deterioration in the health, in the mental health, dementia is usually an example of that. They've gone into a home and there's what we call a DOLS, a deprivation of liberty order that allows the person to be deprived of the liberty in certain circumstances for their own protection. If, for example, they're not going to be road safe and road aware when they go outside. Again, that is one of the more serious matters that the court gets involved with. So, appropriate decisions for the Court of Protection. Well, there are certain type of decisions that are usually appropriate. And again, we've already touched on where the decision concerns serious medical treatment to which the person can't consent, where a decision is difficult or complex and it's hard to ascertain where the person's best interests lie, where there's a dispute or disagreement with a decision made under the best interest decision making procedure which can't be resolved. And as I said, I referred to this on an earlier slide. So when the best interest decision making procedure is being followed, this has to follow finding out if there's any advance statement made by the person when they had capacity, which explains what they want to do. So really trying to find out what their wishes were when they were in a position to make a decision potentially about the issue that is now before the court or before the person making the best interest decision. It's also about considering all the relevant circumstances in the case. So while views may have been expressed earlier, if the situation has changed and circumstances have changed, they will also need to be taken into account as well. then there's the need to encourage the person to contribute to the decision-making process as far as they're able to do so. Then consider the person's past and present wishes and feelings. So even though the person may not have the requisite capacity now to be able to make the decision, they may still be able to express certain wishes and feelings about the circumstances that need to be taken into account. Then there's obviously a need to consider their religious, moral, cultural or political beliefs and values. They are highly likely to feed into any decisions that a person makes, and they would certainly do so if the person in question had the requisite capacity. Also take into account the views of their carers, family, friends and anyone named by them as somebody to be consulted. There is the caveat that unless one of those people holds either an enduring power of attorney or a lasting power of attorney to make welfare decisions, the group of people I've just mentioned, the wishes aren't paramount, so they should be taken into account but not necessarily followed. And then finally, it has to be capable of being shown that the proposed course of action is the least restrictive alternative. Excuse me. So who can apply to the Court of Protection? Well, anybody can apply. The person themselves can apply if they've got a question that the court's got the authority to decide. And if that's the case and the person in question is the applicant, then they don't need the court's permission. They can simply make the application if they're the person that the decision is going to be made about and they're over 18. If the person is under 18, then their legal guardian can apply without permission for the court to make the decision on their behalf. Also, the person's attorney, deputy, or anybody named in a court order relating to the matter that the decision needs to be made about can also apply, and they don't need the court's permission to do so. And finally, family members, healthcare trusts, clinical commissioning groups and local authorities can also apply, but they would need permission from the court to make an application. So when we're looking at a situation that I'm sure a few attendees will have faced, I've certainly faced this, where there's an issue of ending a tenancy on a person's behalf who lacks capacity. The first port of call should always be whether there's a person with an enduring power of attorney or a lasting power of attorney. And the two terms are used because the enduring power of attorney, this allows somebody to be appointed by a person as their attorney to make decisions on their behalf if they lose capacity. And this can relate to property and finances and also welfare, which would include medical treatment. Now, only enduring powers of attorney signed before the 1st of October 2007 can still be used. If an enduring power of attorney was signed after that, it can't be used, and it would need to be a lasting power of attorney. That does essentially the same thing, but they're called different things, so it has to be the correct in the correct format. So it's a lasting power of attorney post 1st of October 2007. If there's nobody with an EPA or an LPA, then you need to ask and double check whether a property or affairs deputy has been appointed. And this is a person who will have been appointed by the Court of Protection to make decisions on behalf of the person in question about that particular subject. So it may be that they can make decisions about where the person lives and or whether they enter into or terminate tenancy agreements. This person will have the support of the Office of the Public Guardian if they need it. They do have a website, which was very useful when I had a look at it when I was preparing for this session. So that is available as a resource. And if there's nobody with that authority to make the decision for the person, then an application will need to be made to the Court of Protection, usually by the local authority, for an order giving the local authority the authority to act. So moving on now to the Court of Protection and antisocial behaviour proceedings. We're most likely to see the Court of Protection involvement, and certainly the cases that I've seen COP involvement has been possession proceedings when we're dealing with antisocial behaviour. And the reason for that is with injunction proceedings, as I'm sure attendees are aware, a person who is the subject of an injunction has to have the capacity to understand any order made and comply with it. The case of Wookey and Wookey from 1991 is still good law. Judges are still referred to that in the Equal Treatment Bench book from July 2022, which is the guidance book that all members of the judiciary get. And an injunction can only be granted against the person if they understand the proceedings and nature requirements of the injunction and can comply with it. So if the Court of Protection are involved because somebody lacks capacity, it's highly unlikely, certainly in my experience, that the person is going to have the capacity to understand an injunction. I don't want to say never ever, because I've no doubt that some weird and wonderful case will crop up at some point in the future to prove me wrong, but it's highly unlikely that we're going to see the cop involved in injunction proceedings. It's much more likely that it's going to be in possession claims. And Section 4 of the Mental Capacity Act sets out a checklist for the purposes of determining what's in a person's best interests. The checklist requires the person who's making those decisions to take specified steps, and the person who is making those decisions has to consider, as far as is reasonably ascertainable, the person's past and present wishes and feelings and any relevant written statement made by them when they had capacity. They have to consider the beliefs and values that would be likely to influence the decision if the person had capacity, and also any other factors that the person will be likely to consider if they were able to do so. And once they've done that, the person making the decision must also take into account, if they're able to do so and it's appropriate to consult them, the views of anybody named by the person as somebody to be consulted on their behalf on matters of that kind. Anybody engaged in caring for the person or interested in the welfare. Anybody who has a lasting power of attorney granted by the person, and then finally any deputy appointed for the person by the court. So we mentioned that the local authority are the most likely agency to apply to the Court of Protection on a person's behalf. And there are several steps that local authorities should take before they decide whether somebody should, for example, move from residential care to supported living accommodation, or the other way around if the person's mental health has deteriorated. And the local authority needs to conduct a needs assessment pursuant to their obligations under the Care Act 2014. And it should really be borne in mind that housing is an integral part of a person's general welfare, and whether the person's in appropriate accommodation should form part of this assessment. So that really is something that needs to be borne in mind. And the local authority also have to draw up a care plan and support plan setting out not only how the person's needs are going to be met, but also how they're going to be funded. So whether they need access to any benefits, funding, etc., if there is particular support needs that need to be met, for example. So again, looking at terminating tenancies, there may be a number of reasons why a person decides to terminate their tenancy. It could be that they need alternative accommodation. It could be that there's been allegations of antisocial behaviour, that a settlement's been reached and that has involved a management move to more appropriate accommodation, for example. If we're going to be looking at a person terminating the tenancy, it's absolutely key that the person's capacity to terminate the tenancy agreement is assessed. And the person has to be able to understand information, retain it, use it, or weigh it, and then communicate their wishes when it comes to terminating the tenancy. This has to include the information and understanding that the termination will bring an end to the rights and liabilities created by the tenancy, so that the person really understands they will no longer be the tenant of that property, they have to move out, and they won't be able to have any rights in relation to the property again. Again, at this stage, it wouldn't have been the subject of judicial consideration, but you have to bear in mind that if any decisions taken around capacity are challenged, this is something that has to hold up to judicial scrutiny. So in terms of making an application to the Court of Protection, there are a number actually of specific court forms when I looked into this that need to be filled in, and some of them do look rather similar to some of the general county court forms that we're all used to. So the COP1 application form has to set out the order or declaration that you're asking the court to make. An application has to be supported either by witness evidence in the form of a witness statement, or you can set out within the COP1 application form, there's a box that allows you to set out why you're asking the court to make the order that you are, verifying it with a statement of truth. And that is very like the N244 form that we're used to seeing in the county courts. Alongside that, there should be what's called a COP3 assessment of capacity form. This has to be included. This will address the person's capacity to terminate the tenancy agreement, as well as addressing whether the person can actually be involved in the court of protection litigation themselves, or whether they need a solicitor, etc. The COP3, so this is the capacity assessment, has to be completed by a practitioner. And a practitioner includes a registered medical practitioner, so the person's GP, a psychiatrist if there's been an assessment done, an approved mental health professional, so if the person has involvement with mental health services already, and they probably will do in all likelihood, a social worker, a psychologist, a nurse, or an occupational therapist. And the practitioners obviously has to have examined and assessed the capacity of the person to whom the application relates. There is also other information that's required when making an application to the COP about property. So there's a form COP 1A that relates specifically to information that the court requires about the property in question. So you'd be given information about the tenancy, the type of property it is, etc. You'd also need in your witness evidence to address why you need the order that you need, what care plan has been put in place, and really address any partnership working and consultation of any other agencies that are involved with the person in question. You'd also need to confirm that a best interest meeting has taken place and attach a copy of the minutes of that meeting. And really at this stage, you will be hoping that an application to the COP is uncontested. You'd be hoping that all agencies, certainly the local authority, social services, housing provider, etc., are all in agreement. And if that's the case, that should be included. And then finally, there is a court fee of £400 that's payable. Obviously, there may be other fees, legal fees, etc. as well, but that is the fee just for making the application to the Court of Protection. And then once the application's made, it will then go before a judge for what's called gatekeeping. So the judge will have a look at the application in the round, decide whether anybody needs to be joined as a party, decide whether there needs to be a hearing listed, or whether the matter can be dealt with on the papers. And as we know, as with all courts really, it will be up to the individual judge as to how they decide to deal with it. If the application's uncontested, then it's unlikely that the person about whom the decision's being made is going to be joined as a party. And where again, the application is uncontested, the hearing is unlikely, although not impossible, and it's more likely that the judge will deal with the application on the papers if all concerned parties are in agreement. And if the application is dealt with on the papers, then the court will issue an order, and it will authorise a named person to sign or terminate the tenancy on the person's behalf. If the application isn't dealt with on the papers and a hearing is listed, then notices will be sent to all relevant parties who need to be present in the usual way. And then once any order's been made, the court will issue it and then matters can be concluded. So for example, if you've got proceedings in the county court that have had to be stayed or adjourned while the Court of Protection made an order, they can then be concluded at that point. And finally, I thought it might be useful if I actually gave a working example that I've got at the moment in my caseload of an antisocial behaviour case where the Court of Protection have become involved. So in my case, the person in question is a defendant in possession proceedings. There was antisocial behaviour reported both by her and about her. The antisocial behaviour by her involved her allegedly stalking neighbours, She also made unsubstantiated and vexatious complaints about her neighbours. She also was prone to confronting them in public in the street about the perceived antisocial behaviour and shouting at them, shouting unsubstantiated allegations about them being drug dealers, reporting them to social services for neglect of the children, etc. Now, the housing provider in question quite rightly took all allegations of antisocial behaviour very seriously and investigated each and every one of them thoroughly. There was no corroborative evidence in relation to the person in question's reports of antisocial behaviour about her neighbours, but there was significant evidence against the person in question regarding her antisocial behaviour. There was mobile phone and ring doorbell footage of her shouting at people, threatening people, and there were numerous witnesses and witness statements about this lady's behaviour. And really, because the situation had been going on for quite a long time, the neighbours were losing patience with this lady, and there were real concerns that she herself was being put at risk because really of a lack of tolerance of the situation and how people were being forced to live in close proximity to one another. So we issued possession proceedings after an injunction was attempted, and there were issues in relation to capacity. So as I said, that is something that is probably highly unlikely when the copper involved. Certainly was in this case, it wasn't appropriate. So possession proceedings were issued. Capacity quite rightly was raised as it had been with the injunction proceedings, and a psychiatric report was obtained in relation to the person. It demonstrated a number of mental health conditions that she had. And as a result of the report, a management move was offered by the housing provider. They had some sympathy with this lady, and relations had clearly broken down between her and her neighbour. Unfortunately, the lady refused the management move, even though she knew she was facing possession proceedings, because, as she put it, she needed to be present to keep tabs on her neighbours. And even though really irrefutable evidence had been provided to her to say there is nothing going on, there is no antisocial behaviour, part of her mental health conditions led to delusions that these incidents that she believed were taking place were genuine. So a multi-agency approach was taken. The psychiatrist and the person in question's solicitor agreed that her remaining at the property was detrimental to her health and that she really did need to move. There was nobody available to act as a litigation friend. There was nobody with an enduring power of attorney, lasting power of attorney, no deputies involved. And so possession proceedings were stayed. They've been stayed a number of times, and this is to enable the local authority to apply to the Court of Protection to allow a decision to be made to terminate the lady's current tenancy and accept a management move to a more suitable property. This will not only take her out of the damaging cycle that she's in, but it would also be closer to her support links and support network. And it's been agreed by all parties that eviction will be very damaging to her mental health, but the situation with the neighbours can't continue. So at the moment, we currently await an update from the local authority involved. As I say, all parties are currently working in the person's best interests, and the hope is that we get the order from the Court of Protection. The lady's tenancy can be terminated, a new tenancy created at the suitable property that's been identified, and then the possession claim can be settled. So that is a bit of a whistle-stop tour. I just thought it was an important area really to look at, as I say, it's becoming more and more prevalent, and it is something that I am dealing with on one of my cases. I'm going to have a look at the Q&A function now. I think we've got a question in already, so I will have a look at that. Please, if anybody's got any questions, feel free. I will stay on for a few moments at least, just to see if there's anything else that anybody would like to ask. Okay, so the question I've got is, would a housing association need permission to apply to the Court of Protection? Yes, they would. However, I would encourage you to do it in conjunction with, or even see if you can get the local authority to do that, because the information that you're going to need from local authority, from social services, you're much more likely to get it if you can get them to come on board. As I say, with social services, there should be best interest meetings, there should be a local mental health team involved. If you want to help fund it, I'm sure they'd be much more likely to respond quicker. So yes, I would say if you can get the local authority on board, do so, but you do need permission unless you're one of the groups of people that I mentioned. Is there a way of expediting hearings? I've been asked. That will very much depend on what your circumstances are, as with the county court. So if you're saying that the situation is urgent and you've got evidence as to that, you could make that application to the court. Again, I imagine that would be done on a case-by-case basis. I'm still waiting for a response in relation to mine. We do keep feeding back in when something else kicks off, if you like. Again, we're trying to nudge the local authority, and hopefully in turn they're trying to nudge the court. So what happens? I've got another question here from Helen Holmes. Hi Helen. What happens if a social worker won't apply to the COP for no good reason and leaves the housing association just to deal with it? I've had this happen numerous times. I'd encourage you, you're not going to want to name names, but I'd encourage you really in terms of partnership working. Is there anybody that you could take that hire with in social services? Because if this person is facing eviction, which they may well do, that is going to be a much greater problem for the local authority to deal with further on down the line than actually playing ball and liaising with yourselves now anyway. As I say, you can ask for permission to apply, but without the local authorities' input, which you'll need anyway, that will just delay matters. So it might be that a management meeting with some senior leadership team from your housing provider and from the relevant local authority might be a way to smooth things over. I would certainly hope that people are working together. So I've got another question. What are your thoughts on dealing with a tenant who's moved into a care home with no capacity being dealt with through the abandonment route? Is this, I don't have a name of the person to be able to go back to them. If this person is under a DOLS, a deprivation of liberty, and they can't return, I would exercise caution with that really. If you want to drop me an email, I'll put my details on at the end, because there are a few different factors that could affect that. You're also going to have to, if you're going to take it to court as well and ask the court to make a possession order, you will have to tell the judge of all the relevant circumstances and whether the judge will truly believe that this person is abandoned, especially if they're under a DOLS. I think you might be on sticky ground there. So if you want to drop me an email with some more details on the case, more than happy to answer that. How do you get a psychiatrist report? Is this via a GP? Excuse me. And what if the person doesn't agree or consent to having assessment? That's a really good question, actually. And it's often something that unfortunately only happens during legal proceedings. So it can be, and the person doesn't have to consent to share their medical information with you. So I often find in cases that I deal with that a person can be behaving in what is perceived to be an antisocial way. Actions taken, so it's either an injunction or possession proceedings, and only at the point where they're served with the papers and they go and get a solicitor is their capacity and/or mental health addressed. We get a psychiatric report, and then at that stage it can be that really information is then given that if it doesn't explain the behaviour, at least gives some insight into what's happening and why. You can ask the person if they will agree to share. You can also ask the local authority if they will share. There are mechanisms under the Crime and Disorder Act 1998 which allow the local authority to share information with you as a housing provider. Good luck in quoting that. I've tried it. It doesn't always work, but you never know. You may get a very helpful mental health team that will share that with you, but there is a lot of nervousness around that, and I can understand it with data protection, GDPR and things like that. There's always some nervousness around that. Okay, I've got another question here. Once possession of the property is obtained from a perpetrator who lacks capacity and is causing ASB, due to the perp's vulnerable status, would the local authority not have a duty of care if they were to approach housing again? The answer is yes, probably, depending on what their condition is. So this is why it would be much better for all parties concerned for the local authority to come on board earlier, and to help with a COP application and find them suitable housing, because otherwise they're just kicking a problem down the road and probably causing themselves or creating a lot more cost and a lot more work for themselves further on down the line. I've got a question here, I think it's from Crystal. What if a person has obvious mental health concerns but won't engage, so no support is being offered? The tenant doesn't think he has any mental health concerns. Unfortunately, Crystal, this can be a symptom of some mental health conditions, that the person actually doesn't think they have any conditions that need to be investigated and or treated. Unfortunately, all you can do as a housing provider is offer support, signpost. If you've got any information at all, I appreciate you may have been told nothing on your sign up forms when the person entered into the tenancy. That's about as much as you can do. And if your hand is forced in terms of taking legal action, if there's antisocial behaviour, again, you've got duties to your other tenants and your other residents, so you'd need to do that. And then hopefully, as part of any proceedings, psychiatric and or medical evidence will come to light and it can be addressed at that stage. This happens all the time, unfortunately. There must be a better way of doing things, but unfortunately we have the system, don't we, that's been designed and that we're working inside at the moment. So that's all you can do, is just signpost. Unfortunately, you can't force somebody unless because the mental health is so bad that they end up being sectioned. But again, that would be very, very severe. I've got a question from a couple of questions from Fiona. How long does it take once you've applied to the court for a COP? That's a bit like, how long does a county court case take? Unfortunately, how long is a piece of string and how busy the court are. The case I'm on, we've been waiting a few months now and we've stayed 3 times. There were some delays in the local authority applying, so that does explain 1.5, if not 2 of the stays, the time periods. But again, unless it's urgent, the court will deal with cases almost like the cab rank, so they'll get to the case when they get to it. Okay, I think I've got another couple of questions. So what happens if the tenant's already been moved by social services due to the risks of the person remaining in the tenancy? The rent's increasing on a weekly basis, which the person remains liable for while the tenancy continues. Does the court of protection always have to be involved if the tenancy is no longer suitable and the person's living elsewhere and receiving benefits? Well, I suppose the answer to that question is, does the person have the capacity to terminate the tenancy? If they have, you can go to them directly and do that. It may be that you need to approach the social worker as well about that, just to evidence that you've done that to protect them. But you could ask them to do that. If not, and they don't have the capacity to terminate, then it will be a court protection and or person with enduring power of attorney, lasting power of attorney, or a deputy. I'll just see if I've got any more questions. So I've got, if there's no power of attorney and a tenant's moving into a care home due to a freak accident and has lost capacity and is paralysed from the neck down, can a sibling end the tenancy with a letter from a medical professional stating that they can't return to the property? Or is a COP still needed? It takes several months and huge rent arrears build up. So there's no power of attorney. The person's lost capacity. They're paralysed from the neck down. I mean, technically, the answer to that is that you should get somebody who has the legal authority to end the tenancy for you, for there to be no issues about it. What you're looking to do is minimise or remove any challenges in the future that a tenancy's been ended unlawfully or inappropriately. And I think in that instance, it may be, I mean, I don't know if there's somebody, are there potentially any successors to the tenancy? Because if there are, they could then potentially bring a challenge in the future. I understand that it can be expensive. I would certainly try and get some information about whether capacity has genuinely been lost or whether, as we know, it can fluctuate and be decision specific and time specific, whether for those purposes, that probably is your first port of call to see whether there's anything that can be done that way. And finally, just to be clear, housing cannot apply directly to the Court of Protection, and so must do so with the local authority. I don't think it's the case, Kate, that you can't apply directly. It's just that if you apply without any local authority information, you're not going to have all the information that I said you need to include in your COP application form. So your best interest meetings with all the professionals, which are going to include local authority, social services, mental health teams. I think if you make an application like that and ask for permission, the court's going to say, well, is this really in the person's best interest? Because you have to remember, the Court of Protection is kind of sitting above everybody, looking at what is in the best interest of this person. And if the housing provider makes an application to get their own tenancy back, the court may well take the view, well, you've got a vested interest as the housing association because you want your own property back to re-let it somewhere else. So we can't be clear that you're definitely acting in that person's best interest. What we need to do is hear from everybody, not just the housing, about what's the best thing. Even though you may well be doing, the court is likely to take the view there's a vested interest because you want your own property back. So I would encourage you to do that. Can the official solicitor terminate a tenancy if it's in the best interests of the person? And there's documentation and evidence to confirm this. Excuse me, or does the official solicitor have to go to the Court of Protection? The official solicitor is there to help a person in litigation. If you are looking to settle litigation by way of terminating a tenancy, I think that's a question you'd have to ask the official solicitor. I have asked that in the past and never got an answer as to whether they will do that or not. So yeah, I would ask the question, but I suspect probably to cover themselves. The Court of Protection is there for that reason. So I would say that you probably need to go to the court, but there's no harm in asking. If you don't ask, you don't get, has always been my motto. I'm just going to check if there are any more questions before I end the session. I'm really grateful to all the questions that have come in. It's obviously a topic that we're finding is more and more, as I say, prevalent. It's not really something that I'd particularly thought about in my practice, and then once you become aware of it and it affects one of your cases, you know, you really then start thinking about how does this fit in, etc. So I'm really grateful to everything that's been on the session today and that's answered. I can also see, thank you very much to everybody who's put in the webinar chat. I think there might be one or two questions in here, so I'm just going to have a look. Oh, so people have suggested immigration. Oh, somebody's asked how long does the process take once it gets to COP? I think we've touched on this. How long's a piece of string? It will depend on how busy they are. I'm sorry, I can't be more helpful. We all know what it's like when you go to the county court. I think it's the same there. So I think unless there are any other questions, I will end the session there. Hopefully there is I'll just put my contact details up there. Hopefully there will be a little questionnaire for you to do. I think Catherine will hopefully put that up. I put my details up there, so if I can help with anything, please do drop me an email or give me a call. And yeah, I mean, I've enjoyed researching this today. It's been really interesting, so I hope you've enjoyed it as well. And as I say, if there's anything else we can help you with, any other sessions, please do put them in the chat and we can take it from there.